land was settled cannot be used it for any purpose other than that for which it was settled. The sued Shabik plot is a vast area. The lease was allotted.
The lessee was
allotted only a small piece of land out of the vast area by the Tahsildar for this specific purpose. The lessee petitioner has not submitted the authenticated copy of the WL case record along with the trace map. It is not worthy to mention that without authenticated copy of WL case record, it is not possible to ascertain the updated position of the case land. Further, the suit land cannot be identified, located without trace map, and any such identity or possession will be illegal, which is bound to generate the multiplicity of litigation. In addition, the petitioner has given sufficient opportunity to submit the documents in support of claim, but the documents are sufficient. Well, here the crux of the matter is that the settlement authority cannot usurp the power of the government land settlement.
No, on what basis you will record your name?
That is there, my lord.
What is there?
And my lord, we are far ahead of that. Because
please satisfy us that
yes, lordship, kindly see
what documents you have produced before the authority to record your name in the ROI.
My lord, the parcha was recorded. Not final ROR is there. There is nothing to be again any objection, because in so much objection they have done in all type of cases out of question.
It comes out from a WLL case.
WLL.
Who was granted lease?
Well, that was, your lordship will find the patta is there, Annex 1.
Who is the leaseholder?
Leaseholder is Noklo Maji.
So his name appearing as Titiban.
Yes, Titiban.
लीज सूत्र नहीं थे परा
आगे
लीज सूत्र नहीं थे
लीज सूत्र मतलब let me have an idea. The WL case, no lease document or anything is recorded. Only the patta is given.
So if you see the patta also, this patta has been issued by Bhubaneswar.
Yes.
The print is, the form is of Keonjhar.
Keonjhar?
Yes.
In the bottom it is there.
Bottom.
Incomplete document there because of in the head.
Again.
Just a minute.
This is the patta.
Again, come to the permission letter. See, the initial given by the Tahsildar, revenue officer, is of 13/8/2000 of 1980, and he is signing it on 31/12/84 according to you.
84 year ta to nahi. 12 khel lekha hai.
Aya. ଆପଣ ତଳେ କହୁଛନ୍ତି ତାହେଲେ କେବେ ସେଟା ଦିଆହେଇଛି? କିନ୍ତୁ ଇନିସିଆଲ ଦିଆହେଇଛି 13/8/80. ସେଟା ପୁଣି ଏକା ସେ ଯୋଉ
କେସ୍ ନମ୍ବର ଉପରେ ଲେଖା ହେଇଛି ରେଭିନ୍ୟୁ ମିସ୍ କେସ୍ ନମ୍ବର 15 of 1984.
ଡାଇରେକ୍ଟର ପରମିଶନ କାରଣ ସେ ଶିଡ୍ୟୁଲ କାଷ୍ଟ ଥିଲା ତ ସେଥିପାଇଁ।
that is
84 ଯଦି ହେଲା ତାହେଲେ ଏଇଟା ଯୋଉ 31/12/1980 କେମିତି ଲେଖା ହେଲା? ସେ ତଳେ ଲେଖା ହେଇଛି
80 मतलब खाली 31/12 ଲେଖା ହେଇଛି ଆଉ ଇୟର
ନାଇଁ ନାଇଁ ଗୋଟେ ସିଲ୍ ଭିତରେ ଦେଖନ୍ତୁ ସିଲ୍ ଭିତରେ
31/12
ଆଉ ଗୋଟେ ସାଇଡ୍
ଲେଖା ହେଇଛି ନା
ଆଉ ଗୋଟେ ଇନିସିଆଲ ଦେଖନ୍ତୁ ସେ ସାଇଡ୍ ରେ ଯୋଉ
13/8
PK ରାହୁଲ ନା କଣ ଏ ସାଇଡ୍
ସେଇ ସେମ୍ ଯିଏ ରେଭିନ୍ୟୁ ଅଫିସର ତାର ସିଗ୍ନେଚର
ମାନେ ସେ ସିଲ୍ ଭିତରେ ମାଇ ଲର୍ଡ କାଇଣ୍ଡଲି ସି
ନାଇଁ 13/8/80 କେମିତି ହବ? ଆପଣ ଯଦି ଇଏଟା ହଉଛି 85 ମସିହାରେ କେସ୍ ଫାଇଲ୍ ହେଲା 80 ମସିହାର ସିଗ୍ନେଚର କେମିତି ଆସିବ ତା ଦେହରେ?
ନାଇଁ 80 ବିଷୟରେ ତ ନାହିଁ।
ଆପଣ ଏଇ ସାଇଡ୍ ରେ ଦେଖୁନାହାନ୍ତି ଏପଟ ସାଇଡ୍ ରେ ଲେଫ୍ଟ ହ୍ୟାଣ୍ଡ
ଦୁଇଟା କରେକ୍ସନ ଅଛି।
ଲେଫ୍ଟ ହ୍ୟାଣ୍ଡ ସାଇଡ୍ ରେ ଯୋଉଠି ଲେଖା ହେଇଛି ଓଗଲ ପଡା ତା ତଳେ ଗୋଟେ ଲେଖା ହେଇଛି ସିଗ୍ନେଚର ଅଛି ତା ତଳେ ଲେଖା ହେଇଛି 13/8/1980।
13/8/80 କି
एनीवे 13/8 ଅଛି କିନ୍ତୁ ଏଇ ସିଗ୍ନେଚର ଅଛି
31/12/84 କିନ୍ତୁ ସିଲ୍ ଭିତରେ
ଆଚ୍ଛା ଯଦି ଏଟା 31/12/84 ତାହେଲେ ଏଟା 13/8 କେମିତି ହବ?
ନାଇଁ 13/8 ଏଟା एक्चुअली 80 ବୋଲି ବି କହି ହବ।
ଆଚ୍ଛା 84 ବି ହେଇଥାଉ କିନ୍ତୁ 13/8 ସେମ୍ ଡେ ରେ ଏଟା ସିଗ୍ନେଚର ନୁହଁ ଆଗରୁ ତାହେଲେ କେମିତି କଲେ ସେ ଅଫିସର? So there are some disputed question of fact can be taken up by civil court.
କଥା ହଉଛି କଣ ଯେ
these documents are apparently appears to be not
ପାର୍ଚାଟା ଦେଖନ୍ତୁ ଆନେକ୍ସର 6 ରେ ଅଲରେଡି ଯେତେବେଳେ ଲ୍ୟାଣ୍ଡ ଟା ରେକର୍ଡ ହେଇ ସାରିଲା
ଅକୁଳ ମାଝି ଜମି ତାକୁ ଦେଇଥିଲେ से नकुल माझी ताकू से लीज कहीं से तार कोन टर्म्स एंड कंडीशन थिला सी का को बिकिला आपण केमती आसिले
एटा सेल डीड अछि एनेक्सर 4
सेल डीड
हां रजिस्टर्ड सेल डीड
नहीं एसो तो कहउचंती डब्ल्यूएलएल केस रे आछि बोली व्हेयर इज दैट डब्ल्यूएलएल केस
my lord it is that time my lord your lordship
will be a story then
ନାଇଁ ସେ କଣ ହେଇଛି ନା ସେତେବେଳର ସବୁ ଜମି ଯୋଉଟା ଡବ୍ଲ୍ୟୁଏଲ ରୁ ଆସିଥିଲା
that is different sir if at all anything is there you will
revenue
case to
secretary
case
said
basis
मतलब revenue secretary said
we are giving another opportunity to produce the document before the ASO and if he is satisfied matter is different otherwise
but your lordship will find from that judgment
no that judgment that is that creating a lot of problem
but your lordship has
just
passed an order
mechanically it is
my lordship has passed an order
yes the petitioner Prafullo Kumar Swai
my lord now the SO is there in a major settlement office
while
that camp is no more there
while the petition for quashing the order
then civil court is the actual
8/2013 passed in objection case number so and so under annexure 9 of the opposite party number 5 and consequential ROR so prepared under annexure 8 in respect of the civil land. The impugned order indicates that in spite of giving sufficient opportunity to produce the document in support of the claim, the documents which were produced were insufficient. And therefore, the ASO was of the view that there was every reason to record the suit land as Avadi Yoga on Avadi Khata. Mr. Mohanty, and senior advocate appearing for the petitioner, submits that the petitioner has got valid documents in his possession, and if an opportunity is provided, he will produce before the authority, and the authority may be directed to reconsider the same in accordance with law. When counsel for the state has no serious objection to such prayer without expressing any opinion on the merits and in view of the submission made by the land counsel for the petitioner, we grant another opportunity while setting aside the order like that. We grant an opportunity to the petitioner to produce all the documents for recording his name in the ROR. And needless to say that if the SO is satisfied that the documents produced by this one so are insufficient, is at liberty to pass any order according to the writ petition is disposed of.
Lordship kindly give a deadline so that
एक तीन चार पांच
1, 3, 4, 5
all right
and 11 also.
3, 4, 5 and 11.
11 also.
Oh.
My lord, may I pray, Lord,
3,
your
4,
lordship
5.
give a deadline to appear before him and
produced before the within 2 weeks for the and the order to be passed within 3 months for them and if possible and if necessary for them to give an opportunity of hearing the petition.
my lord, the ASO Jal I have stated,
Yes.
now this office shifted to major settlement office.
Then automatically you have to go for 24 OSS Act, sir. Civil court is the authority then.
My lord, here below your lordship, judgment is there, lordship must give liberty that Northam case I will show there.
That is a open
that's a
document.
judgment of the issue. You can place it before yes next.
Oblige.
Item number 2.
Wherein the writ petition is washing of the
Is this similar one
similar
like yesterday?
which I was doing, only annexure 3 and 4, there the letters were annexure 4 and calculation sheet was annexure 3.
Item number कितना है? Item
number WPC 28163 of 2024.
Item number
Kalikar serial number 9.
9.
Issue notice
Issue notice stay.
author number 7. ठीक था
ଆଜ୍ଞା annexures ଖାଲି ତା ଭିତରେ ଟିକେ ଏପଟ ସେପଟ।
ହଁ ଦେଇଦେବେ ଟିକେ
ମୁଁ
annexure ଟା ଟିକେ ଦେଇଦେବେ।
ଲେଖି urgent setback
Item number 6.
ଅନ୍ୟ ଡେଟ୍ କର।
ପାସୱାର୍ଡ କୁହନ୍ତୁ ଲାଷ୍ଟକୁ ଆଉ ଥରେ ଡାକିଦେବେ ନହେଲେ ନାହିଁ ଆଉ
Item 7.
adjournment means what is your good name?
Khageshwar Behera.
Mr. Khageshwar Behera. Khageshwar Behera, Land Council appearing for the petitioner 6 for an adjournment. कितने दिन दरकार adjournment?
After 1 week, let's say.
After 1 week.
Let's may pardon my lords. It's item number 6. Actually.
Yes, yes.
Item 9.
No, please 6.
6.
Item 6.
No,
It's
he's
item number 6. A similar order has been passed. One of the similar matters by this honorable judge.
Dispose of it,
No, my lords. Notice has been issued.
My lord, let them serve the copy of the same. Railway is the party.
ତା ଦେହରେ ଯାହା ଅର୍ଡର ଅଛି ମିଷ୍ଟର ସେଗୁଡାକ ସବୁ ଲେଖା ହେଇଛି କପି ଆପଣଙ୍କୁ ଦବା ପାଇଁ ସେ ଯୋଉ ଆଗରୁ ଗୋଟେ ସିମିଲାର ମ୍ୟାଟର ସେମ୍ ଅର୍ଡର ମିଷ୍ଟର ପାଢୀ ଦ୍ୟାଟ ଉଡ୍ ବି ଦି ଅର୍ଡର ଆଇ ଥିଙ୍କ
Oblige, my lord. Yes. Oblige.
this is the 6 plus 6
ୟା ଦେହରେ କିଛି ଚେଞ୍ଜ ଚାଞ୍ଜ ଅଛି ନା ସବୁ ସେ ରେସ୍ପୋଣ୍ଡେଣ୍ଟ ଯାହା ସବୁ ଠିକ
No, my lords. There will be changes. The LMS case will be changed. The order date will
ହେଲେ
be.
ମିସକେସ୍ ଟା ଖାଲି ଚେଞ୍ଜ ହବ
Lordship.
ଆଉ ସିନିୟର ସିଭିଲ ଜଜ୍ କାମାକ୍ଷା ନଗରଟା ଚେଞ୍ଜ ହବ
No, my lords. That is same.
that is same
Lordship.
so you have made the also the what Mr. Pari said that you have made
2 and
3 and 3 is a party so for that you have to serve notice on
Lordship.
Mr. Pari
Lordship.
so the party number 3 serve a copy on
Yes,
Mr. Pari
is there
का
order?
नाम लिखा वो दे दीजिए
Sir, slip the we're providing a list.
हाँ जी अच्छी तो
अच्छी।
नहीं नहीं ठीक है अच्छी
अच्छी।
They do, sorry. No,
Okay.
just name.
issue notice one
eight. Adjourn. नले अच्छा हाँ
हाँ
Item number 9.
8.
Out of petitioner's land, well, petition has acquired the items of NH number 10. Not to petitioner.
Though there was a house over the acquired land, no compensation was paid. The petitioner made a representation to the RDC under Annexure 9, page 18. The RDC write to the collector of Sambalpur,
no your representation is annexure 8
Annexure 8.
so that is
Now, on the basis of that representation,
yes
the RDC directed the
Additional secretary to RDC.
yes, yes.
Oh no, collector district magistrate to inquiry.
Again.
A
So the
has been
direction
on
was
the
given
basis
to
of
the collector to deal
so
with
what
the matter.
happened thereafter you have not got any
Not instruction. Nothing has happened till date.
Collector is a party.
Yes, sir. Opposite part number 3. Collector cum chairman, district compensation advisory committee.
one so this petition has been filed with swans of prayer and counsel for the petitioner submitted that highlighting the grievances of the petitioner and taking the grounds taken in this writ petition he submitted a representation before the RDC RDC bracket collection
North Division,
North Division
Sambalpur.
that is opposite party number
3.
no RDC it's 2 no
No, 2. Sorry, 2.
And the same was forwarded to the collector and district magistrate Sambalpur by letter dated 6/1/2026 by annexure 9. Collector tahle opposite party number 3. But till date with a with instruction to uh, take appropriate action as per prevailing provisions of law if it is found to be a genuine case. But the opposite party number so and so has not uh, given any, he has not received, the petitioner has not received any communication from the opposite party number so and so. Still direction. 3 months further from the date of production of the certified copy, collector has to consider the same. If necessary, personal hearing is to be given, and within 2 weeks, the taking the decision, the them shall be communicated. Yes.
Obliged.
Item number 10.
Again, I'm back to the square one, in fact. This matter, after your lordship set aside that order dated 38/2024, the commissioner, the RDC openly commented that you have come after setting aside my order again. I'll just place one thing on it. If your lordship kindly turn to the order passed by your lordship first. That is annexure 23, page 131. The 137 page is the operative portion. Since the order of withdrawal of the status quo appears to be cryptic in nature, it seems that the RDC has not heard both the parties before passing such order, had not tried to ascertain as to whether the averment taken in the application of the petitioner relating to carrying out the construction work in spite of the status quo order to be correct or not. We set aside the order of withdrawal of status quo dated 38/2024 on Annexure 22, direct the RTC to hear the matter reference relating to continuance of status quo order till disposal of the OJC appeal. After appearance of the opposite party 4 and 5 on 18/10/2024, the date was fixed 18/10. If the OGLS appeal is not taken up on merit on that day, because other side is to appear 4 and 5, the status quo order, the application relating to continuous status quo till the disposal appeal shall be taken up on that day, along with the objection, if any, filed to such application, and after hearing all parties, order shall be passed in that respect. However, we expect no opinion. Well, if you lordship kindly turn to the order merit. Sir, unfortunately, on that day I was absent. Over page 152, 18/10/2024. Case record is put up today at page 152. Appellant submits an application to adjourn the hearing to another date on the ground that senior advocate is not available. It's a holiday, sir. 18th was a holiday, puja holiday. To personal work outside the state, through the direction of the Honorable High Court, dated so and so, wherein the Honorable High Court had set aside the order dated 38/2024, directed this court to hear the matter reference today relating to continuance of the status quo order earlier passed with this, in case the OGLS appeal is not taken up on merit. Hence, the compliance with the above direction, Honorable High Court, the application to shift the hearing of the two another is rejected. So I just said 3 days time be granted because I was held up in Ranchi, in fact. It is seen from the speed post track report that notice was served on government opposite parties 4 and 5 on 39/24. Hence, the case is taken up for hearing on the merit. He didn't hear the matter on continuance of the status quo order. My young friend was there, associate was there, and the court said, no, I'll dispose of the matter, you file a written note. In fact, no argument was heard, nothing was done. So I am not saying that to set aside and remit it back. I don't want to go there again. But kindly look at the order on merit. A written note was filed, in fact, giving detail of the chronological events. That is from 154 onwards. And citations were given at page 166 to 168. then the impugned order with the subject matter of challenge is dated 171. Sir, before I take your lordship to the impugned order, sir, can I just apprise your lordship one thing? So previously the leases were granted on the lease principle. After the OGLS Act came into force, leases were granted under the OGLS Act. So those are supposed to be governed under the provision of the statute. Sir, OGLS Act, the WL cases, as your lordship was asking, my friend. So those are wasteland lease cases. In those Bhubaneswar area where the city was developed, there are a lot of vacant land, bushy lands, forest type growth, and barren lands were there. So government wanted to set up different colonies. So they wanted to give it to landless persons. So they find out landless, agricultural farmer, and all those categories there. In those cases, they don't charge premium. They take yearly rent. Here is a case where a hotel is to be established. So one has to apply to the government for setting up a hotel. Then the single window recommends. After the single window recommends, the land is identified. If more than one person, then the lottery or auction that is held. So we came up under that category. We paid a premium of 15 lakhs. The land premium has been paid. Annual rent of 15,000 every year has to be paid. Everything has been set out of the condition. These type of lease, you cannot cancel, showing that you have not used it for such purpose. This type of lease, an agreement is executed. Lease deed is executed. But in WL case, actually no lease is executed. They only give a jamabandi where they mention you cannot alienate the property within this time. Previously it was 5 years under the OLR Act. Now it is 10 years. So you cannot alienate. And if you want to alienate within that, you have to seek permission of the authorities, Tahsildar or ADM, whoever be there. These cases, when I am a lessee, an agreement has been executed, parties are bound by the terms of the agreement. Am I clear, Lord? So I'll just take your lordship to the lease deed some terms. The kindly turn to Annexure 2. 3. 75. 75.
Yes.
Yes, 75. If you lordship turn to page 77.
Yes.
Towards a 1 acre land, approximately more particular describes so Ginger Hotel, including quarters of its office employees, together with all rights easement appurtenant thereto belonging to any way appurtenant thereof, to hold the said demised land in the lease from the date of execution of this deed in terms of 99 years. So they are like a permanent lease. Then so 99 years for a premium of 15 lakhs only as per the in respect of because so the yearly rent has been fixed at 15% plus cess and everything. If your lordship turns to the previous page at page 74, this would have been annexed later on. I have already paid that premium and annual rent is being paid. 15 lakhs, 26,250 at page 74. But these terms and conditions, if your lordship looks at, sir, page 78. Page 78. Clause 5 and 6 are important. It says the lessee shall start construction of Ginger Hotel, other constructions and installations for the purpose of ancillary thereto, including quarters for the office and other employees, within 90 days of delivery of possession of the demised land. Number 1. 6 says, clause 6, that lessee shall complete the construction of Ginger Hotel or other structure and installation within a period of 3 years of delivery of possession of the demised land. These are the conditions which are laid down, and the repercussion thereof can be turned to page 79. Clause 2. Upon the breach of or non-observation of any of the conditions of the lease, herein granted, Malad got it, Malad? Granted, the lessor may declare that the lease has been determined, and the collector Jagatsinghpur or any officer or person appointed on that behalf by the lessor shall be entitled to re-enter and take possession of the demised land of the building other structures erected thereon, and the materials thereof, as well as stocks and stocks, provided, however, that is very important, my lord, that before such re-entry, lessor shall give to the lessee a written notice of his intention to do so, and the lessee shall have the right to remedy the breach. That means if I have happily constructed, I have to construct it within 3 months. Namnasar is complained of within 3 months from the date of such notice, in which event lessor shall not be entitled to re-enter and take possession. So this is a mandatory. You have to give me notice that we are going to take possession unless you rectify or complete the construction within a particular period. Then, sir, kindly turn to the next page, page 80. Question of resumption, how it comes. That should the demised land, well, I got it?
Yeah.
Should the demised land or any part thereof at any time required by the government of Orissa for any purpose declared by the government to be public purpose, the lessor shall be entitled to resume the land, demised land, and such part thereof are giving 6 months notice. And on giving 6 months notice, writing, on the expiry of the said period, may through any officer authorize the government in this behalf to re-enter and take possession of the land, demised land, or part thereof, or all building and structure thereof, provided that under no circumstances whatsoever, except the breach of the covenant contained therein, lessor shall be entitled to resume possession of the demised land. So these are the conditions. And the next part, provided that in case such re-entry, the lessor shall be entitled to compensation for building and other structure erected by him on the demised land. There is a complete lease deed where the terms and conditions has been codified. Well, kindly look at annexure 10, my lord. First notice, then annexure 10 also. Notice to it.
Annexure 9.
Huh?
Page 89.
Page 89, my lord. No, it didn't reply. Sir, 88. I'm sorry, extremely sorry. Page 88. I stand corrected. Annexure 8. And a year before, they have asked for the rent and everything that I have deposited also paid. It says, you are hereby informed that you have failed to use the government land as detailed below, leased out in your favor. For the
This is of
purpose.
the year 23.
Miller.
Okay. You deposited in 2006.
Yes, yes.
Yes.
And also the subsequent rent and cess has been paid. If Lordship looks at page 86. These are few payments that has been made for the relevant year. Page 86 and 87 as well. Payment of property tax and everything. So that was demanded also.
Notice was issued because 2 grounds as it appears in the first paragraph.
My lord, absolutely.
Yes, please come.
2-6 executed on 14 Number 1, 2-6. That is you have not utilized it within the time prescribed. Then what is the recourse, my lord? As the terms and condition, you should give a notice.
Yes.
Notice to rectify. If I don't do it within 3 months, then you can take action, take delivery position. Sir, here the possession part is not mentioned. Well, one part of it is missing. But I gave a reply to this. So kindly turn to page 89. I have specifically stated. Sir, first paragraph itself, third line. And to allow Root Corporation Limited to complete the construction of the proposed Ginger Hotel, so-and-so, that I sought for time to complete it, my lord. That's my reply. I have given why actually there has been a delay also, that is I have explained. And I have also indicated I have raised some construction, not that I have not intention to do it. Then, sir, kindly turn to page 90. I have also brought to the notice of the court the adjoining land which was also given to another hotel. To our understanding, it is important to note that during the time of allotment of the premises to RCL, that Root Corporation Limited, another bidding process was also undertaken and completed, whereby the immediate next plot of land of the premise was allotted to another company for the construction of another hotel. The bidding of the allotment was undertaken the same time. The construction of the said hotel premise was commenced about a year ago. Just yara borse aguru seta construction heichi. Reason being, there was a dispute regarding demarcation of both the plots. And demarcation report also have filed. If
So what happened then? What the Tahsildar did?
Sir, the Tahsildar demarcated him. Sir,
About this, after this notice was issued and
yes,
you
yes,
filed your...
exact. Sir, kindly look at page 92. Page 92 and accept 10. That is the subject matter of dispute, which was challenged. In read, Honorable Court said you filed an appeal, I filed an appeal. In pursuance of the condition laid down in serial number 3 of the office so in exercise of the power vested on 3B, the following scheduled land in favor of is resumed, which is absolutely illegal because number one, no reason has been assigned in the order. Number two, they have not followed the terms and conditions of the lease deed. So 3B, the application is completely different. Here I have paid the premium. There's a document has been executed. You must justify that in spite of my objection, so-called given. It's satisfied that it has to be.
You are right, Mr. Mishra, that this order at least does not indicate that you have that he has considered your objection.
Nothing has been
done, or any hearing was given. Nothing. Simple and order as far.
Order.
So against that, you approach the
RTC. I approach this Honorable Court. Honorable Court said you go and file an appeal.
What the
now kindly see the improved order.
Yeah.
Now, sir, kindly turn to the improved order. The impugned order starts at page 171.
No, come to the relevant.
Relevant. I am coming to the relevant part.
The same ground. The lease is complete.
Hence, it is clear. Have you got it?
Yes.
Hence, it is clear that if the construction of the hotel is not completed within 3 years of possession, the lessor has a right to resume the land as per clause 4. So, actually, not right to resume. They have to give a notice, terminate, then give a chance to rectify. Resumption is in public purpose. Clause 4 of the lease deed. The so-cause by Tahsildar Kujang was issued on 24/8/23. After affording ample opportunity more than 16 years to complete the hotel. Where is the opportunity, sir? After providing opportunity to personal hearing and considering the written reply contain no valid ground, the impugned order has been rightly issued by the collector Jagatsinghpur. Therefore, he praised that the order requires no interference. I peruse the document submitted, including the detailed written argument by the applicant, carefully considered the argument by both parties. The claimant claimed that, I'm sorry.
Where this collector Jagatsinghpur came, I think it was passed.
This is in Paradip.
Paradip.
That order was passed, which you showed, that was passed by Tahsildar, I think.
That resumption order?
Collector.
Collector.
Okay.
Collector.
Collector.
Okay.
Collector.
The notice was issued by Tahsildar. That please see that again. Because
notice has been given by Tahsildar.
And you also filed your so-cause before the Tahsildar.
Yes.
And
was placed before the collector.
Sir.
Condition number 3 later. What is this? This collector's that condition laid down in serial number 3 of the office sanction order. What is that condition? Please show us once again. जोटा annexure 10 रे लिखा है जी 6 page 92 रे
annexure 10 sir
annexure 10 page 92
yes sir
तो ऊपर लिखा है जी in pursuance to the condition laid down
that is to be completed within 3 years.
Yes, that's the lease deed.
Completed within 3 of the lease deed.
That's the lease deed.
That you have not completed the construction within 3 years.
And if it is not completed, then according to that agreement or that lease deed,
you should notice of termination first.
Okay.
Then you should notice of taking possession and give me a chance to complete the construction if it has not been fully completed. Then question of taking over will arise.
That is as per that
terms and conditions of the lease deed. Sir, can you see the way actually it is mentioned? Can you kindly look at the order? 174 minutes. They have analyzed at the 213 amendment of OGLS Act. In page 174 top is applied retrospectively to him is not acceptable for 2 reasons. Collector is the competent authority under OGLS Act and rules sanction lease 1 acre of land. He has sanctioned by order to so and so. Hence, any amendment of the Act be applicable to all such leases. Sir, that retrospectivity is also subject matter challenge in other rate applications, the virus of it. It must be noted here that 2013 amendment allowed additional time of 3 years from the date of amendment. It is not a case of appellant he was issued so-called notice in 2016.
So for all the opposite party, state is there or somebody else is appearing? There are
State
in
is
this
there,
writ
state is
petition.
Only state.
You have mentioned 1, 2,
Department of
four,
Tourism, Revenue
6
Service.
opposite parties are there.
So ଗୋଟେ ଜିନିଷ ଦେଖିବେ ସେ ଗୋଟେ ଲାଷ୍ଟ ସେଣ୍ଟେନ୍ସ 174 ପେଜ ର ଲାଷ୍ଟ but fourth ଲାଇନ ଟା ଦେଖନ୍ତୁ. It is not disputed that applicant has given more than 5 times of the duration mentioned in the lease agreement to
No,
complete the work.
that
So it-
part is all right.
Court
All
will
right.
abide with it.
After taking the land on lease,
Sir.
no construction has been brought up. That is all right. But then you have to follow the
Yes,
rules.
terms and
You have to
conditions.
issue notice, termination, other aspects. You
Right,
have
sir.
to see that they proceed with the
Yes, sir, what
construction.
has happened?
This 16 years is
I'll
correct.
tell something out of the court. Sir, actually, it is a attempt by them to give it to somebody else immediately. Sir, I have laid the foundation.
No, here
I have
this
laid the pillars.
No, here this could be, maybe this could be one of the reason, but it is seen invariably
Sir.
that lease are being taken and hotels and properties are not being brought up for years until you find that now it is good time that you should bring your hotel. So that is the
Sir.
whole thing.
Sir, in fact, Rahul Kela matter also one of the matter I am appearing that it will come to your worship for hearing. In fact, so now they have widely throughout Odisha also they have developed hotels and it is serving the public purpose in the tourism department. So it's a considered attempt to give it to somebody else. So now this status code was passed by the RDC, the first RDC. The second RDC comes and vacates it. Your worship set aside that order. Status quo was there throughout.
All right. This writ petition has been filed by so and so with a prayer for a direction to so and so, so and so. The Mr. Mishral and senior advocate submitted that referring to Annexure 27, which is the order dated 18/10/2024 of the RDC, Central Division Cuttack, bracket opposite party number so and so, that when the matter was taken up on that day, an application was filed by the appellant to adjourn the case to another date.
Adjourning for 3 days only.
For on the ground that senior advocate is not available and is out of state. However, the RDC didn't adjourn the matter, and shown in the order dated 18/10/2024 that the arguments have been heard and directed the appellant counsel to file the written note of submission. He further submits that written note of submission was filed and several grounds were taken, including the citations. However, the impugned order would show that the points raised by the on behalf of the petitioner has not been taken into account. The Land Council placed the lease agreement, which is at Annexure 3, and submitted that the agreement itself,
The lease deed.
so the lease deed itself indicates that if there would be any breach or non-observance of any of the condition of the lease, what is to be done? And the uh, the same has not been followed in the present case. He submitted that the petitioner received a notice from Tahsildar Ujang, bracket opposite party number so and so, which is dated 24/8/2023, and he submitted his reply. However, without giving any opportunity of hearing or taking into account the points raised in the reply, the Collector District Magistrate Jagatsinghpur by Annexure 10 passed the order on dated 16/9/2023. That the lease case number so and so is resumed in favor of the Revenue and Disaster Management Department, Government of Odisha. It is the submission of the Land Council for the petitioner that since the procedure for a resumption has not been properly made, and it is against the terms and condition as laid down in the lease agreement, the same is not sustainable in the law. So also,
Tahsildar issued notice, collector passes the order.
so also the imprint order, which has been mechanically passed without taking the grounds which has been taken in the written note of argument. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the state accepts notice on behalf of all the opposite parties. Extra
Copy number 3 is the
Lease corporation.
opposite parties number 1, 2, and 4, 5, 6. Extra copies of the writ petition be served on the Land Council for the state. So far as opposite party number 3 is concerned, is there any panel
I'll
council?
take a registered no.
The
I'll take a registered post.
requisites for issuance of notice by speed post with proof of delivery shall be filed within a week. Matter will be listed 4 weeks thereafter, and counter affidavit, if any, be filed in the meantime. That's all, Mr.
The status quo was there till the order.
IA number so and so, status quo shall be maintained until further orders.
That's it.
Yes. Also, the
VTP jurors. Already here the appellant petitioner has been convicted under section 341, 323, 307, 506,
Mr. Patna, kindly come closer to the
341.
what is the custody date?
Custody, my lord, is in custody is 24/6/2013. In the meantime, he has already undergone 11 years, 5 months.
And in this appeal, you have never been released on bail.
Interim was passed,
what
my lord, on
what date?
28th March 2023.
28 March 23.
2083, and he surrendered on 31/7/2023.
That was granted for how many months? 4 months.
4 months.
Okay. So on merit, your bail application was rejected, but taking into account the period of detention, you are granted interim bail, right?
And it was extended for 2 months more.
Yes.
नहीं और extension तो है
Extend है ही नहीं.
ना extension है extension application file
Application है तो है.
reject कर दिया अल्लाह. So any kind of
Mallards
violation
directed to get a report. A report has come, Mallards, where it has been mentioned that interim bail conducted the petitioner so and so cordial with everyone, and during this period he was engaged in extension work of his house. Nothing adverse found against him.
is found. Okay.
3/8/2020.
Just a minute, let us see.
Right. Right.
28 ରେ
ହେଇଥିଲା order.
order ଟା ହେଇଥିଲା.
ତାପରେ ଏଟା
This is an application for extension of the interim bail order going through the. So we are we are not disputed. We are inclined to extend. Extension ହେଇଛି ତ
extension 2 ମାସ ଆହୁରି.
for ଆଚ୍ଛା ତାପରେ ଆଉ ଇଏ ହେଇନି.
ତାପରେ
ହଁ so ତାପରେ 2 ମାସ ହେଇଛି ଏବଂ ଦେଖିକି ସେଟା କଣ ଆସିଲା report. ପାଖାପାଖି ରହୁଛନ୍ତି ସେମାନେ ଇଏ ହେଇଯିବ ଆପଣଙ୍କର ଏମିତି ହେଇଥିଲେ ହେଇଥାନ୍ତା 11 ବର୍ଷ କେତେ 13 ମସିହାରେ ଆପଣଙ୍କର 24/6/2013 ତାମାନେ ଆପଣ 6 ମାସ ଜଣେ ଯାଇଛନ୍ତି 4 ପ୍ରଥମେ
ये 2 मास
3 ମାସ ଏକ୍ସଟେନସନ ହେଲା. Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted the trial court report that you have to final form that the petitioner was taken into judicial custody on 24/6/2013 and he was never released on bail during trial and during the pendency of the appeal. He was granted interim bail for a period of 4 months as per the order dated 28/3/2023, which was extended for another 2 months as per order dated 3/8/2023. And after availing the interim bail order, the petitioner surrendered at right time. On the last date, we asked the learned counsel for the state to produce the report from the concerned IIC regarding the conduct of the petitioner while he was on interim bail. And today the learned counsel for the state has produced the report of the IIC, Jajpur Police Station, dated 27/11/2024, wherein it is mentioned that the conduct of the petitioner was cordial with everyone, and during the period of interim bail, he was engaged in extension work of his house and nothing adverse was found against him. The report is taken on record. Considering the submission made by the learned counsel for the respective parties, the period of detention in judicial custody, the conduct of the petitioner during interim bail period, we are inclined to grant him interim bail for a period of 3 months.
I may be pardoned, my lord. I am appearing on behalf of Dayanand Mahapatra for the informant, my lord. My instruction from the client is that on the last occasion when he was released on interim bail, he was engaged in, as per the instruction my learned brother submitted, he was engaged in extension of housework. This ERLA has been arising out because of there is a civil dispute between the informant and the accused person, my lord. On last occasion, when he was in interim bail, there is a threatening, he was giving threatening to us. So that my humble submission is that some condition may be imposed to that effect, my lord.
He shall not run counsel for the informant, however, oppose the prayer for bail छुट्टी लिखी देवे सकते है ना? During the period of interim bail, he shall not indulge in any criminal activities, है ना? And shall not try to come in contact with the family members of the deceased. Uh, and violation of any terms and conditions shall entail cancellation of bail. Matter be placed to answer, surrender certificate to be filed. Yes. Okay.
Item 13.
In 47/2013.
No, why it has come? You have not filed any application for bail.
Yes, my lord, hearing list will
No. The paperwork has not been prepared, so what is the question of
already. So I will file and
if you file
yes.
let's not do so the Land Council for the appellant submitted that the Land Council for the appellant submitted that the paperwork the registry may be directed to expedite the preparation of the paperwork. Let this matter in the week commencing from January to May. In the meantime, a paper will be prepared, and giving copy to the Land Council for the respective parties. Yes. Next.
Item 14.
So the prisoner's petition has come for your engagement. Have you filed your wakalat now?
My lord, I am engaged with amicus curiae earlier.
Acha. Okay. In case, acha, yes, in Prithulananda Sahu engaged with him. Where is Mr. Sahu?
It's not.
My lord. Sorry, man.
Prisoner petition has come for engagement of Mr. Gokulananda Sahu.
Yes, my lord. My lord.
यहाँ किसी नंबर भी देना. Since it's a jail criminal appeal, please see the High Court DASH.
My lord, will.
Maybe
we'll get
taking it after 1 week. We'll just find out.
Yes, ma'am. Will.
And if the number you find, just give it.
My lord, will contact. Yes.
Fill the prisoner's petition at flag A regarding engagement of Mr. Gokulananda Sahu. However, Mr. Sahu has not appeared in court. The Land Council for the state submits that he will find out the Land Council and intimate him. Put up this matter in the week commencing from 16th of December 2020. All right.
My lord, my presence may be.
No, let us see. We'll name the be there. Don't be.
Item 15.
Item 15, my lord. It's order against challenging imprisonment for life and fine 40,000. LCR may be called for. And co-accused in CRLA number.
No, it has
1131.
Means it has not been admitted.
My lord.
It has not been admitted or what?
Not been admitted.
So why then it has come for orders? Is there anything limitation is there? Has been delay? No. 60 days. No delay, no delay. Limitation was 60 days, but he has there is no delay.
Co-accused also filed CRS number 1131.
No, we just wanted to know that why it has come for orders, not admission if there is no defect. Day of relation. नहीं admission है इसे ना पर admission ही है हाँ कौन पे असले admission admission पे कौन पे असला defect तो नहीं ना এটা नहीं तो admission में असला था ये order से कौन पे असला like hard admit solve for the trial court record interim application for bail and stay realization of fines be considered after receipt of the trial court. You have received the appeal memo and judgment.
Yes, ma'am. Yes.
And also interim application.
Yes, ma'am.
Okay. We can